Question 1. A California notary public who willfully and knowingly engages in misconduct may be held liable for A. A maximum of $1,500 in civil penalties. B. All damages proximately caused by the misconduct. C. Revocation of their commission with no financial penalty. D. A fine determined by the person who was harmed. Answer: B. All damages proximately caused by the misconduct. Willful misconduct is a serious breach of a notary's duties, and the financial liability is not capped at a specific amount. The notary is responsible for covering all financial losses that are a direct result of their improper action, which underscores the importance of following notarial law precisely. For instance, if a notary knowingly notarizes a fraudulent signature on a property deed, they could be liable for the entire value of the property lost in the transaction. Remember that your liability isn't limited by a set fine, it's tied directly to the harm you cause. Question 2. The primary purpose of an acknowledgement is for the signer to A. Swear that the contents of the document are true. B. Declare that they signed the document. C. Certify a copy of their birth certificate. D. Authorize the notary to complete the document. Answer: B. Declare that they signed the document. An acknowledgement is a formal declaration before a notary that the signer personally executed, or signed, the document. The notary's role is to verify the identity of the person making this declaration, not to attest to the truthfulness of the document's contents, which is the function of a jurat. For example, when someone signs a grant deed, the acknowledgement proves they are the person who willingly signed it. The key takeaway is to associate acknowledgement with admitting or confirming the act of signing. Question 3. When a member of the public requests a copy of a line item from a notary's journal, the notary may charge a maximum fee of A. $15. B. $1. C. 30 cents. D. A reasonable amount. Answer: C. 30 cents. California law sets a specific, very low fee for providing a copy of a journal line item to a member of the public who submits a written request. This fee is 30 cents per line item, reflecting that the journal is a public record and access should be affordable. This contrasts with the much higher fee allowed for performing a notarial act itself, such as an acknowledgement or jurat. Always remember to distinguish between fees for notarial acts and fees for administrative tasks like providing journal copies. Question 4. A notary is asked to notarize a document that is incomplete. The notary should A. Complete the document based on the signer's verbal instructions. B. Refuse to notarize until the document is completed. C. Cross out the blank spaces and proceed with the notarization. D. Advise the signer on the correct information to fill in. Answer: B. Refuse to notarize until the document is completed. A notary public must refuse to notarize any document that contains blank spaces or is otherwise incomplete, as this creates a significant risk of fraud. Leaving blanks allows information to be filled in after the notarization, potentially altering the document's original intent. The correct procedure is to return the document to the signer and explain that it cannot be notarized until all spaces are filled in or lined through by the signer. A good rule of thumb is, if there's a blank, the process comes to a halt. Question 5. A credible witness used to identify a signer must A. Have known the notary for at least 5 years. B. Be named in the document being notarized. C. Be personally known to the notary. D. Be a family member of the signer. Answer: C. Be personally known to the notary. When a signer lacks acceptable identification, their identity can be established through a credible witness, but that witness must be someone the notary personally knows. This personal knowledge provides a trustworthy link between the notary and the signer, ensuring the chain of identification is reliable. For example, if your longtime neighbor, whom you know well, brings in their friend who lost their wallet, your neighbor could serve as a credible witness. The core principle here is that the notary's personal knowledge of the witness is what makes the identification valid. Question 6. If a notary's official seal is lost, stolen, or damaged, the notary must A. Immediately notify the Secretary of State in writing. B. Order a new seal and wait for it to arrive before taking action. C. Notify the local county clerk's office within 10 days. D. Publish a notice in a local newspaper for 30 days. Answer: A. Immediately notify the Secretary of State in writing. The security of the official seal is paramount, and its loss must be reported to the Secretary of State immediately and in writing. This prompt notification helps prevent the lost or stolen seal from being used for fraudulent purposes. Waiting to act or notifying the wrong agency could compromise public trust and lead to unauthorized notarial acts being performed with your seal. Think of your seal as being as important as your credit cards. If it's lost, you report it to the central authority right away. Question 7. A notary is disqualified from notarizing a document if they have a direct financial or beneficial interest. This means the notary A. Is being paid the standard fee for the notarial service. B. Works for the same company as the signer. C. Is named as a party in the document, such as a grantee or trustee. D. Knows the signer personally. Answer: C. Is named as a party in the document, such as a grantee or trustee. A direct financial or beneficial interest exists when the notary is a direct party to the transaction or will receive a direct financial benefit from it, beyond a standard notary fee. Being named as a grantee, receiving property, a trustee, or a beneficiary in the document itself creates a clear conflict of interest that disqualifies the notary. Simply being paid your fee or working for the same company is not considered a direct interest in the transaction itself. The key is to ask yourself, am I a party to this transaction or will I gain something from it beyond my fee? Question 8. The term of a California Notary Public Commission is A. 2 years. B. 4 years. C. 5 years. D. 6 years. Answer: B. 4 years. A notary public commission in California is valid for a 4-year term, beginning on the date specified in the commission certificate. Notaries must keep track of their commission expiration date to ensure they apply for reappointment in a timely manner to avoid any lapse in their authority to notarize. This 4-year cycle requires notaries to stay current with any changes in law and to retake the state exam as part of the renewal process. A simple way to remember is that it aligns with many election cycles, making 4 years a common term length for official positions. Question 9. For which notarial act must the notary witness the signing of the document? A. Acknowledgement. B. Proof of execution by subscribing witness. C. Jurat. D. Certifying a copy of a power of attorney. Answer: C. Jurat. A jurat requires that the signer execute the document in the presence of the notary after taking an oath or affirmation that the statements within are true. The key phrase often seen in a jurat certificate is subscribed and sworn to, or affirmed, before me, where subscribed means signed. Unlike an acknowledgement, where the signature can be placed on the document beforehand, a jurat's validity depends on the notary witnessing the act of signing. Think of a jurat as a 2-step process you must see, the oath and the signature. Question 10. A notary must keep their sequential journal of notarial acts. A. In a public place for easy access by clients. B. At the county clerk's office. C. In a locked and secure area under their direct and exclusive control. D. With their employer, if the employer paid for the commission. Answer: C. In a locked and secure area under their direct and exclusive control. The notary journal contains sensitive personal information about signers, and the law requires the notary to protect it diligently. It must be kept in a locked, secure area that only the notary can access, ensuring the privacy of the entries and preventing tampering or theft. Even if an employer pays for the notary's commission and supplies, the journal remains the sole property and responsibility of the notary. Always remember that you alone are the guardian of your journal's security. Question 11. The venue on a notarial certificate indicates: A. The location where the signer lives. B. The county where the document will be filed. C. The state and county where the notarization took place. D. The notary's home address. Answer: C. The state and county where the notarization took place. The venue, typically written as State of California, County of ________________________________________________________________________________________________________________ establishes the geographical location where the notary and signer were physically present at the time of the notarization. It confirms the notary was acting within their jurisdiction when they performed the notarial act. For example, if you meet a signer in a coffee shop in Los Angeles County to notarize a document, the venue must state County of Los Angeles. A helpful tip is to think of the venue as the scene of the crime. It's where the notarial act actually happened. Question 12. In California, an identification card issued by a federally recognized tribal government is: A. Never acceptable as proof of identity. B. Acceptable only if it includes a photograph and signature. C. An acceptable form of identification. D. Acceptable only for notarizing tribal documents. Answer: C. An acceptable form of identification. California law specifies a list of acceptable forms of identification, and this list includes an ID card issued by a federally recognized tribal government. To be valid for notarization, the ID must be current or issued within the last 5 years, contain a photograph, a physical description, a signature of the person, and a serial number. This provision ensures that members of tribal nations have a valid means of proving their identity for notarial acts. A good practice is to keep a current list of all acceptable IDs handy for quick reference. Question 13. When a person is unable to sign their name and instead uses a mark, what is required? A. The notary must sign the person's name next to the mark. B. The mark must be witnessed by one person who writes the signer's name. C. The mark must be witnessed by 2 persons, one of whom must write the person's name next to the mark. D. The use of a mark is not permitted for notarized documents in California. Answer: C. The mark must be witnessed by 2 persons, one of whom must write the person's name next to the mark. California has a specific procedure for a signature by mark to ensure its validity and prevent fraud. The signer makes their mark, like an X, in the notary's presence, and 2 witnesses must also be present to observe this. One of the witnesses must then write the signer's name next to the mark, and both witnesses must sign the document as witnesses. This 2-witness rule provides a strong verification that the person with the mark intended to execute the document. Question 14. Upon resigning a notary commission, a notary must deliver their journals and papers to: A. The Secretary of State in Sacramento. B. The county clerk of the county where their current oath is on file. C. Their employer if the employer paid for the supplies. D. Any other active notary public for safekeeping. Answer: B. The county clerk of the county where their current oath is on file. When a notary's commission ends for any reason, resignation, retirement, or death, their official records do not simply disappear. The law requires all notarial journals and papers to be turned over to the clerk of the county where the notary's most recent oath of office is filed, typically within 30 days. This ensures that the public records contained within the journals are preserved and remain accessible for future legal proceedings. Remember, your records belong to the public, and the county clerk is their final custodian. Question 15. A notary public may not advertise their services using the literal Spanish translation, notario público, because a. It is a registered trademark of the Secretary of State. b. In Spanish-speaking cultures, this term implies the person is an attorney. c. It is considered unprofessional. d. The English language must be used in all advertising. Answer: b. In Spanish-speaking cultures, this term implies the person is an attorney. In many Latin American countries, a notario público is a highly trained legal professional with powers far exceeding those of a U.S. notary. Using this term in California is strictly prohibited because it can mislead immigrants into believing the notary is qualified to provide legal advice on matters like immigration. This restriction is a key consumer protection measure to prevent the unauthorized practice of law. Always advertise your services clearly as a notary public and include a disclaimer that you are not an attorney. Question 16. A notary public must record which of the following in their journal for every notarial act? A. The signer's occupation. B. A photograph of the signer. C. The fee charged for the notarial act. D. The reason the document is being notarized. Answer: C. The fee charged for the notarial act. The notary journal entry serves as a complete record of the notarization, and California law mandates several required elements for each entry, including the fee. Recording the fee charged for each act provides a clear and transparent record, protecting both the public and the notary from disputes over payment. While other details like the type of act and signature are required, things like the signer's job or the document's purpose are not. Always double-check that your journal entry is complete before finishing, and make sure the fee is documented. Question 17. A proof of execution by a subscribing witness may be performed when a. The principal signer cannot appear before the notary. b. The document has already been filed with the county recorder. c. The subscribing witness is also the principal signer. D. The notary personally knows the principal signer. Answer: A. The principal signer cannot appear before the notary. A proof of execution is a special notarial act used when the person who signed the document, the principal, cannot personally appear before a notary. Instead, a subscribing witness, who watched the principal sign the document, or heard the principal acknowledge their signature, appears before the notary on the principal's behalf. The notary then verifies the identity of the subscribing witness, who signs the notary journal and takes an oath regarding the principal's signature. This act provides a way to notarize a signature indirectly when a personal appearance is impossible. Question 18. A notary must decline to notarize a signature on a document if the signer presents a California driver's license that a. Was issued 3 years ago. b. Is a temporary paper license. c. Expired 6 years ago. d. Has a different address than the signer's current one. Answer: C. Expired 6 years ago. While California law allows notaries to accept certain expired identification cards, there is a limit to how old they can be. A valid ID must be current or, if expired, must have been issued within the past 5 years. An ID that expired 6 years ago falls outside this 5-year window and is therefore unacceptable, forcing the notary to refuse the notarization unless the signer can provide another valid form of ID. Remember the 5-year rule for expired IDs to avoid making a critical error. Question 19. If a single document requires notarization for 3 different signatures, and each signature requires a separate acknowledgement, a California notary may charge a. 1 fee for the entire document. b. A fee for each acknowledgement performed. c. A maximum of 2 fees, regardless of the number of signatures. d. An hourly rate for the service. Answer: b. A fee for each acknowledgement performed. Notary fees are charged per notarial act, not per document or per person. If a document has 3 signers and each requires their own separate acknowledgement certificate, the notary is performing 3 distinct notarial acts. Therefore, the notary is entitled to charge the maximum state-allowed fee for each of the 3 acknowledgements. Think of it this way: each time you complete a notarial certificate and stamp it, you have performed 1 chargeable service. Question 20. A notary's official stamp, seal, must contain all the following except: A. The state seal. B. The notary's commission expiration date. C. The name of the notary as it appears on the commission. D. The county where the notary's oath is on file. Answer: C. The notary's home address. California Government Code specifies exactly what information must be on a notary's official seal to ensure its uniformity and validity. This includes the notary's name, the words "Notary Public," the state seal, the county of the oath, the commission expiration date, and the manufacturer's ID number. A notary's personal information, such as their home address or phone number, is never included on the seal, as it is not relevant to the Notarial Act and would pose a privacy risk. A great tip is to memorize the short list of required seal elements so you can easily spot what doesn't belong. Question 21. Before performing a jurat, a notary must administer: A. An acknowledgement. B. A warning about the penalties of perjury. C. An oath or affirmation to the signer. D. A test of the signer's competency. Answer: C. An oath or affirmation to the signer. The defining characteristic of a jurat is that the signer is put under oath or affirmation regarding the truthfulness of the document's contents. The notary must administer this oath before the document is signed in the notary's presence. An oath is a solemn promise to a deity, while an affirmation is an equivalent promise made on one's personal honor, ensuring the requirement is accessible to people of all beliefs. Remember, a jurat always involves swearing or affirming, making it a more serious act than a simple acknowledgement. Question 22. A notary public is legally authorized to do which of the following? A. Certify a copy of a birth certificate. B. Give advice on which type of notarial certificate to use. C. Certify a copy of a power of attorney. D. Notarize a will. Answer: C. Certify a copy of a power of attorney. California law gives notaries the specific and unique authority to certify copies of powers of attorney. This is one of the very few instances where a notary can certify a copy of a document. Notaries are strictly forbidden from certifying copies of vital records like birth, death, or marriage certificates, as only the recording agency, like the county recorder or Department of Health, can do so. A key rule to remember is that unless the law explicitly grants you the power to certify a copy, you cannot do it. Question 23. If a notary changes their business or home address, they must notify the Secretary of State. A. Within 30 days. B. Within 60 days. C. The next time they renew their commission. D. Only if they also change their county of residence. Answer: A. Within 30 days. A notary is required by law to keep the Secretary of State informed of any change to their business or home address to ensure they can be contacted for official matters. This notification must be submitted in writing, by certified mail or another means of delivery providing a receipt, within 30 days of the move. Failing to update your address is a violation of notary law and can result in fines. Make it a habit to treat a change of address with the same urgency as updating your driver's license. Question 24. A loose notarial certificate must contain which specific warning language? A. This certificate should be stored in a safe place. B. This certificate must be attached to the document described. C. This is a legal document, consult an attorney if you have questions. D. A notary public is not a legal advisor. Answer: B. This certificate must be attached to the document described. When a notary has to use a separate, or loose, notarial certificate because the original document lacks the proper wording or space, a specific disclaimer is required by law. This wording states that the certificate must be securely attached to the document it describes and provides identifying information about that document. This is a critical fraud prevention measure, as it prevents the loose certificate from being attached to a different, unauthorized document. Always double-check that this mandatory text is present on any loose certificate you use. Question 25. A notary may be required to surrender their journal to a peace officer when A. The officer has a reasonable suspicion of criminal activity. B. The officer has a subpoena or a court order. C. The officer requests it as part of a routine business check. D. The officer is investigating the signer of a document. Answer: B. The officer has a subpoena or a court order. While a notary's journal is a public record in some respects, it contains sensitive information and cannot be seized without due process. A peace officer can only demand to take possession of the journal if they present a valid legal instrument, such as a subpoena, warrant, or other court order. In such cases, the notary must surrender the journal but should also immediately notify the Secretary of State about the surrender. Think of your journal as protected information. It can only be taken from you with proper legal authority.